schedule as prepared by the Secretariat, and hopefully we'll be able to abide by the schedule and do so quite closely, but always with the necessary flexibility to adjust to whatever circumstances may arise during the hearing. I will be presenting the members of the Tribunal and the Secretary, and then I will invite the parties to do their own introductions. Then I will also give the floor afterwards, not right now, but afterwards, to the parties in the event they may have any points they wish to raise right now, whether it be a matter of organization or whatever having to do with the hearing. So I am Diego Fernandez Arroyo. I'm the president of this tribunal. To my right, I have Professor Marcelo Cohen, co-arbitrator, and to my left, Mr. Christian Leithley. The secretary of the tribunal is Ms. Marisa Planes Valero. And without further ado, I'd like to give the floor now to the representatives of the claimant. Microphone.
My name is Richard Lorenzo. I'm a partner with Hogan Lovells, and I'm joined this morning to my right by my partner, Maria Eugenia Ramirez, my partner, Mark Cheskin, my colleague, Juliana de Valdenebro, and of course our client, Michael Lee Chin, Anthony Lee Chin, Lorraine Sullivan, and Dr. Powellen. Thank you, sir.
Thank you very much. Respondent, please.
Buenos días a todos. Mi nombre es Claudia Frutos.
Good morning. I'm Claudia Frutos Peterson from Curtis Mallet-Prevost Colton Mosul. I'm here together with my colleagues representing the Dominican Republic. To my right, my colleague Belén Ibáñez. To my left, my partner Gabriela Alvarez and my partner Fernando Tupa. Next to Fernando, we have Natalia Linares, also from Curtis. Behind me, we've got Jacqueline Messimer, our paralegal. And Stefania isn't here right now. But then beyond Natalia, we've got Marcelo Salazar, director from the Administration for International Treaties and Agreements, and Lady Lynn Contreras, also from that office. She's the deputy director. Raquel de la Rosa, and she's an analyst from this same office of the International Trade Treaties and Agreements of the Republic. Next to her, Ms. Patricia Abreu Fernandez, Vice Minister for International Cooperation at the Minister for the Environment and Natural Resources. Next to Ms. Abreu, we have Rosa Otero Nieves, Director of International Relations at the Ministry of the Environment and Natural Resources of the Dominican Republic. And next to her, Mr. Emmanuel Rosario Esteves, who is an advisor of the Office of the Minister for the Environment and Natural Resources of the Republic. And lastly, but not least, Ms. Joana Montero de los Santos, responsible for the Trade Department and Environment of the Ministry of Environment and Natural Resources. Thank you very much. As I said earlier, I'd like to now ask the claimant whether they have any prior point.
Demandada?
No.
Respondent? No, nothing. Thank you, Mr. President. I don't know if there are any housekeeping issues to be raised right now. No, nothing right now, says the Secretary. Very well. Microphone?
Podemos ir a...
Then let us move on and we'll give the floor.
Beginning with the respondent.
I'm sorry. Please.
Disculpa, sí. Sí, adelante, por favor. Thank you very much. Thank you very much, Mr. President. Distinguished members of the tribunal, as proven throughout the different allegations and writs presented by the Dominican Republic, and as will be confirmed throughout this hearing, this is a case that should never have started, as it is quite clear that the Dominican Republic has not consented to submit this controversy to an international arbitration under the UNCITRAL rules. Therefore, the Republic supports and alleges that, very respectfully, that this tribunal does not have jurisdiction to understand this and hear this dispute. The Republic presented two solid jurisdictional objections. The first one, presented by the Republic, has to do, as I mentioned earlier, with the lack of consent of the Republic to present this dispute to arbitration in accordance with the UNCITRAL rule. Article 13 of Annex 3 of the Free Trade Agreement between the Dominican Republic and the Caribbean Community, CARICOM, and for purposes of this presentation, I'm going to refer just to the treaty in general terms, does not have an offer for consent by the Republic to an arbitration under the UNCITRAL regulations. The second objection is based on the fact that indirect investors and indirect investments do not enjoy protection under the treaty. Either one of these two objections independently lead to the same outcome. In other words, that the tribunal does not have jurisdiction to hear this case. Before going into detail in each of these jurisdictional objections, there are some comments we'd like to make having to do with the rejoinder from the claimant. First of all, if there is something for which it is characterized, in addition to its poverty, lack of the arguments, and distortion of provisions in the positions of the Republic and several relevant provisions, it is most importantly its aggressive and insulting nature with direct and personal attacks to the Republic and its attorneys. The claimant, incredibly, reaches the extreme of accusing the Curtis Council without any grounds to violate their duty of being honest and open before this tribunal. Apparently, counsel for the claimant are offended by the successful record of Curtis in other cases of investment arbitration where they have been able to prove the lack of consent by the state under investment laws and international treaties. In its strategy of accusing the Curtis attorneys and trying to expose them to this tribunal, counsel for the claimant don't rebut the cases gained by Curtis in this matter in particular, and they cite exclusively two cases in which Curtis represented the state. I'm referring to the cases of Garanti Cosa versus Turkmenistan and Venezuela US versus Venezuela. However, what the claimant does not say is that in these two cases, the tribunals unanimously determined that there had been no jurisdiction in accordance with the particular provision of the treaty, as was precisely alleged by Curtis. Nonetheless, the majority in those two cases decided that the state's consent could be imported by means of the Most Favored Nation Clause, MFN. Now, as the allegations by the Republic have been shown, these cases have been strongly criticized by the doctrine and jurisprudence, but they have serious dissident opinions. But these are not relevant for the case that we have before us, because in those two cases, the clause for dispute resolution contained in the treaties are diametrically opposed to that clause in this case. I will refer to those two cases in greater detail as we move on. Now, it would have been interesting that instead of accusations, the lawyers for claimant would have responded to the legal arguments that we presented and distinguished doctrine and jurisprudence on which we base our allegations. We believe that in reading the memorials presented by the parties and analyzing the relevance of arguments and legal authorities underpinning them, the tribunal may decide on its own which is the party that has violated its duty to be honest and candid in this case. Secondly, in its response, the claimant also accuses the Republic of not having delivered intentionally a complete work of the preparatory work for the treaty and to not have attempted to find them by the given date by the tribunal, requesting in an absurd and unjustified manner for the tribunal to do a negative inference against the Republic. There is nothing further away from reality. The Republic has conducted an exhaustive search and made tremendous efforts to locate these documents. Let us recall, members of the tribunal, that we're talking about documents that are over 20 years old. This search was conducted in all the files of the different state agencies and offices that could potentially have them, sending communications to different state agencies and entities. Not even after the phase of document presentation. All this is duly explained in the binder for this case. The travaux préparatoires for the treaty that were found were immediately sent and complete sets to the claimant before the respondent presented its reply on jurisdiction, so there was no harm or damage whatsoever upon claimant. As pointed out in a timely fashion, there was a fire in the files of the Ministry of Foreign Affairs of the Republic, and the documents relating to the preparatory work of the treaty were not found in the general archives nor any of the archives of other state offices with which we got in touch. To the surprise of everyone, the central bank in its archives had documents relating to these preparatory work, which, as I said, these were fully shared as soon as they were found. It is therefore absurd to accuse the Republic of bad faith when precisely it is the party that is most interested in presenting these documents that undoubtedly, as we already pointed out, support the opposition. If there is something that results obvious from reading these preparatory works is that they confirm the inexistence of consent to uncitral arbitration in the treaty. In these two matters, unfortunately, the only conclusion that can be drawn is that one can see this aggressive tone, distortions, and unfounded accusations by the claimant, and it's simply a matter of despair and frustration that they are expressing. The frustration to not be able to use serious legal and convincing arguments to rebut the solid arguments of the respondent. Neither the Republic nor its counsel will enter into this field of personal attacks. We know that the tribunal will assess the evidence presented and the legal arguments made, as well as documents, doctrine, jurisprudence supporting each and every one of its arguments, and will be able to draw its own conclusions. Going back to the rejoinder by claimant, the first thing one sees is that this memorial, contrary to previous memorials, is not accompanied by a new legal report from the claimant's expert, Professor Paulin. The claimant's arguments having to do with the alleged consent of the Republic to the uncitral arbitration. There is a technical problem, interrupts the President. It seems to be a problem with the transcript in Spanish.
Se excusaron los cables.
Es que estaba, por ejemplo, está así como Latinoamérica, o sea, estaba pasando.
Es que abajo hay una audiencia de ellos, el único centro de